represents a key pillar for resilient and inclusive knowledge societies, as well as sustainable development. Protecting and promoting access to information improves transparent governance, helps protect our health, reduces inequalities, contributes to sustainable development, strengthens resilience, and addresses climate change. When we have to face a global crisis, whether it concerns our health or saving our planet, it becomes vital to have what the Sustainable Development Goals urge us to achieve, namely public access to information and fundamental freedoms as part of our future. Access to Information Day 2021 will highlight the role of access to information laws and, vitally, their actual implementation to build back effective, accountable, and inclusive institutions for the public good. It will focus on how countries need specialized and strong oversight bodies to ensure that governments make information available proactively, as well as to respond to public queries. Each citizen should take ownership of their right to information to ensure that they can make informed decisions. And with regards to the best interests of humanity and the earth we live on. On September 28th and 29th, join our series of webinars and all the online events organized by Unesco and its partners across the world to protect and celebrate our right to access information. Please visit our website for more information.
Hello, good morning, good afternoon, and good evening, depending on when you are, where you are joining us. My name is Michael Nicholas, and I'm the Executive Director of the UCLA Institute for Technology, Law, and Policy, and I'd like to welcome you to this, our second panel for the celebrations of International Day for Universal Access to Information. This panel, which will run for 90 minutes, addresses oversight structures for the right to information, particularly the sorts of information commissions or commissioners, which international standards suggest are integral to a well-functioning right to information system. Around the world, the right to information exists across a wide variety of legislative, political, and cultural contexts. But one commonality, certainly that I've seen, at least across all of these systems, is some measure of institutional or bureaucratic resistance against transparency. And at their core, the right to information, access to information, these are all public accountability mechanisms. And accountability, for all its importance, is generally not a pleasant process for the folks that are on the receiving end of it. It is an important process. It is a valuable process for the institutions that are subjected to it. But generally, it's not fun, at least for the officials that have to implement it or are subject to it. And one of the reasons why oversight is so important is in order to overcome this kind of resistance. You can develop the most progressive legal framework in the world. It won't be worth very much if you don't have an oversight system in place to make sure it's properly implemented in line with the spirit of the law. So we are very fortunate today to have a wonderfully well-qualified panel to discuss this challenge, including representatives from 4 different oversight bodies, as well as one of the leading civil society organizations working in this space. This is to be an interactive and dynamic webinar, so we're very much encourage your participation throughout. We're going to begin with a series of 5-minute interventions from our esteemed panelists to introduce their thoughts on this issue, followed by a brief discussion among the panelists, followed by questions from the audience who can enter their questions via the chat box that you can see below. So we will begin, but first we will begin with a video presentation to introduce the International Conference of Information Commissioners. Do we have that queued up, the introductory video for the ICIC?
The members of the Executive Committee of the International Conference of Information Commissioners, the ICIC, integrated by the Information and Data Protection Commissioner of Albania, the Office of the Information Commissioner of Bermudas, the Office of the Comptroller General of Brazil, Chilean Transparency Council, the Commission on Administrative Justice Office of the Ombudsman of Kenya, the Information Regulator of South Africa, the Office of Government Information Services of the United States, and the National Institute for Transparency, Access to Information, and Personal Data Protection of Mexico welcome you to this activity.
Since 2016, every September 28, the International Day for Universal Access to Information is celebrated globally. This date provides us the opportunity to review the action carried out and visualize future challenges in order to advance in fully guaranteeing right of access to information in our societies.
With the theme, The Right to Know, Building Back Better with Access to Information, the United Nations Educational, Scientific, and Cultural Organization, UNESCO, celebrates the International Day highlighting the importance of access to information laws and their implementation to build back strong institutions for public good and sustainable development, to be achieved in the spirit of the Decade of Action.
Unesco and ISIC join effort to make a call to access to information bodies to adopt the declaration, which is aimed to contribute to the global, local, and people action pointed to a strengthened implementation of SDG 16.10.2. In this sense, the panel entitled The Importance of Independence and Efficiency of Oversight Bodies and the Legal Framework looks to discuss regional specificities of implementing the right to information and analyze how can their independence and efficiency be guaranteed of strengthened.
My name is Commissioner Lucy Dungo, Access to Information Commissioner in the Commission on Administrative Justice, the Ombudsman, Kenya. As a global network, each of the ICIC 64 authorities from 35 countries work to ensure that they foster the protection and promotion of access to public information as a fundamental milestone of social, economic, and democratic governance.
Besides, the ICC has issued two joint statements, namely, I quote, ICC access to information in the context of a global pandemic COVID-19 and COVID-19, the duty to document does not cease in a crisis. It becomes essential, close quote. These statements support a flexible approach that takes into account the compelling public interest in the current health emergency while safeguarding the value of the right to access information.
Likewise, by monitoring regional progress on access to information, the ICIC offers its members the opportunity to identify and exchange best practices and experiences developed at a global level. The ICIC and UNESCO carry out cooperation mechanisms addressed to strengthen access to information by the promotion of ATI laws, as well as building capacities of dedicated access to information bodies and highlighting the importance of international cooperation in the field of access to information for environment, health, and human rights.
Access to information is an essential tool to promote and strengthen citizens' trust and participation, achieving as consequence more democratic, egalitarian, and inclusive societies. Therefore, ATI bodies, citizens, civil society, and international organizations are faced with the opportunity to continue building this right for the benefit of our societies. We invite you to follow us on our social network and be part of the conversation with the hashtag pointed on the screen. Thank you very much.
Okay, thank you so much for that, which I think is a great grounding of the issue and the ICIC. We will start now with the introductory interventions, going first to Elizabeth Tidd, the Chief Executive Officer and Information Commissioner of the Information and Privacy Commission for New South Wales, Australia. As a statutory appointee and executive leader, Elizabeth has implemented regulatory reform across legal, public, not-for-profit, and commercial sectors, and she has a deep understanding of integrity and governance from a statutory board and executive perspective. Over to you, Elizabeth.
Thank you, Michael. It's my great honour to join this panel this evening Australian time. One of the contributions that I would like to make in advancing the right to know is to give you some insights as to what we're doing in Australia this week for Right to Know Day. And we celebrate that over a week, but also importantly share with you some of the highlights of 10 years worth of GIPA, Government Information Public Access Act, which is the statute that I'm responsible for oversighting in New South Wales. Now, there's a requirement under that Act for all agencies to report on outcomes, application numbers, determinations. And every year I table a report in the New South Wales Parliament. This year I had the great pleasure of tabling 10 years worth of GIPA data. So I might turn to the next slide, thank you, and I can take you to some of those highlights in very brief form. So firstly, what was the legislation designed to do? Because we did have in New South Wales a Freedom of Information Act. It operated from a restrictive or exception-based approach. This legislation was designed to represent a tranche 2 in legislation. It was to promote proactive disclosure and, in fact, mandated proactive disclosure in different sectors, for example, in the government sector and the local government sector. Those mandates were calibrated to identified risk, such as the risk of corruption because of pecuniary interests or otherwise. Asset disposal and acquisition by government departments was also a requirement. So there's a number of proactive disclosure requirements. That was new. There is a presumption in favour of disclosure and therefore the public interest in disclosure, and oversight by an independent champion of open government, a new information commissioner. And that's the role I currently occupy. If I could have the next slide, please. So to give you some of the high-level insights of 10 years of data, an extraordinary growth in applications from members of the public, from 6,000 in 2010 to 13,724, I think that figure is there, 690 in 2020. Now that's a 128% increase. Interestingly, the applications seeking personal information have increased at a staggering rate, 230% increase from 3,000 applications in 2010 to 10,000 applications in 2020. Release rates for members of the public, because this legislation was designed to enshrine the right of the public to access information, has hovered between about 65 and 70%. Interestingly, over the last 4 years, release rates for private sector businesses has become higher at around 75%. We've coupled some of our insights with ongoing year-on-year community attitude surveys, and we're finding that the New South Wales community consistently report that between 88 and 90% of citizens in New South Wales value their right to access information. Next slide, please. This is some of the interesting and more contemporary features that we're starting to see. There is a conclusive overriding public interest consideration against disclosure in relation to cabinet in confidence information. And as you would appreciate, that caveat, as we call it, applies to government departments, because that's the heart of government and cabinet decision making. In the first 3 years, we collectively reported upon two groups: state-owned corporations, so quasi-public-private entities, and government departments collectively. And that was always around 8.5. 4 years ago, we decoupled, and we have seen a staggering increase in a reliance upon cabinet in confidence by state-owned corporations, and they're arguably moving further away from the heart of government, yet they have increased over the last couple of years from 33% to now 67%. So in 3 years, there's been a staggering growth, and one has to ask why, given that these are sometimes private-public partnership entities, and they are not necessarily dealing with current cabinet matters because they are providing the business that they're established to provide. If I could have the next slide, please. Mandatory proactive disclosure. It's very clear that in terms of responding to formal access applications, government departments over 10 years, and in fact all sectors over 10 years have improved, and their timeliness has improved, notwithstanding a trajectory of increasing applications. But in terms of the mandatory proactive disclosure requirements that I started with, we have very low rates of compliance. And this raises the issue of what does an independent oversight agency do to achieve compliance in respect of a mandatory requirement. So we only have, as you can see here, 2 departments with a full and partial list of major assets and acquisitions. They're not all reporting on both the numerical value and the monetary value, and they're required to do so under the Act. Likewise, they're required to publish a guarantee of service, and only 1 department did that. We're also seeing extremely low levels of compliance by local councils in respect of their requirement to disclose the pecuniary and other interests of local councillors and key officials. And that's something I've undertaken in an independent audit, looking at about 1/3 or 32 local councils in New South Wales. Next slide, please. So that concludes my very brief summary. I hope within time, but I also hope it ignites some questions and assists us in looking at what are the threats, how might we better manage those threats, and what sort of powers do oversight entities need, and importantly, how do they measure compliance? Thank you. Thank you, Michael.
Wonderful. Thank you so much for that. We will go next for introductory remarks to Quinn Mchugh, Executive Director of Article 19. Ms. Mchugh has a background in community building, environmental activism, and protection of human rights in the digital age, and her work whose work targets her organization towards innovation in the field of expression and right to information.
Thank you very much, Michael, and thank you to Unesco for this opportunity to speak today. And thank you to Elizabeth for that excellent example of kind of the principles in practice and how those are being put into place in New South Wales. That was a really interesting overview. I wanted to just pitch my remarks a little bit at this issue that the legal frameworks and some of the gaps that we're seeing. Because one of the issues that we have right now is that right to know is enshrined in law in a number of places in the world. In fact, it's the right to know laws have never been so prevalent as they have been. Over 121 countries have adopted comprehensive right to information laws, which equates to about 90% of the world's population currently living in a country with an RTI law or a policy. 96 of these countries specifically include the right to information in their constitution. Tunisia, prior to the coup, being one of the countries that was most recent in this regard. And 78 countries, another sign of kind of proactive implementation of RTI, have joined the Open Government Partnership. And another 32 countries have pending RTI bills or other initiatives. So we can see at the legal level, there are a number of countries that have made that first step into having some form of right to information laws on the books. Now, we all know that there's a difference between the access rights and access in practice. And so I wanted to first just go through a couple of the principles that my organization, Article 19, which works closely where we can with information commissioners and others to really put forward a practice that will enable people to realize their rights, so that it goes from something that is abstract to something tangible and people can use to make their own lives and that's their communities better. That's the heart of why right to information was included in the Sustainable Development Goals. So from our perspective, there are 9 principles and best practice, and these principles start to bridge this gap between laws and implementation. The first principle is maximum disclosure, that right to information legislation should be guided by the principle of maximum disclosure in all states. There's an obligation to publish, principle number 2, where public bodies should be under an obligation to publish key information. Elizabeth just mentioned this in terms of the proactive disclosure elements of the law in New South Wales. Number 3, a promotion of open government. So public bodies must actively seek to promote open government in themselves and in other elements of government. The 4th principle starts getting initially to a little bit of what Elizabeth was saying towards the end in terms of providing a limited scope for exceptions. So exceptions to the proactive disclosure and right to information should be clearly and narrowly drawn and subject to strict harm and public interest tests. Now, there's what we call the 3 parts test for limiting freedom of expression and information in international standards. The first of this 3-part test is that there must be a legitimate aim for the restriction of information as provided for in international law. The second part of the test is that the disclosure must threaten to cause substantial harm to that aim. And the third part is that the harm to the aim must be greater than the public interest in having information. So it poses a quite high bar for when exceptions to public disclosure should be made. Now, the 5th principle is a process to facilitate access, where requests for information should be processed rapidly and fairly, and that an independent review of any refusals should be available. This in particular, this principle 5, was where we saw a lot of things basically fall down during the pandemic and are still problematic, where requests for information were denied or were not able to be processed in any kind of timely way. And this is just at a moment when access to reliable information was more important than ever, more important for people's health and also to build public trust. The 6th principle, in terms of best practice on right to know, is around cost. So individuals should not be deterred from obtaining public information by costs. We've seen a number of ways of trying to make this a more exclusive right by putting costs which seem nominal in some regards, but can be a high barrier to entry for people actually accessing their rights. The 7th principle is around open meetings. So meetings of public bodies should be open to the public. The 8th principle is that disclosure should take precedence. So that laws which are inconsistent with the principles of maximum disclosure should be amended or repealed. And finally, from our perspective, the 9th principle for right to know is around the protection of whistleblowers. So individuals who release information on wrongdoing, as Michael mentioned at the beginning, accountability is hard, right? It's difficult for people to be held accountable. Whistleblowers must be protected. So these are some of the elements that we think should be there, both in terms of the legal standards, but also in terms of the way that things need to be implemented on the ground. Now, I don't know if we were asked to provide a case study, and I actually have one in terms of bridging this implementation gap between law and practice that actually came during the pandemic from my hometown of Washington, D.C., where the mayor of Washington, D.C. set up this quite comprehensive COVID information dashboard, which was updated weekly, as well as the situational briefing that was given weekly, once at the beginning in person and then routinely through information being put out. And I think I may be able to share my screen to show the dashboard here, but let's see if this works. Oh. Right, can people see the screen in the slides there? If not, I'll just speak to it. So the first element of what really made this special was the Washington, D.C., the mayor took it upon themselves to have strong proactive disclosure to try and answer people's questions about the status of the pandemic before it was there. So the dashboard that was put out was publicly accessible, was also published in terms of newspapers and made available at different public access points in Washington, D.C. And it touched on a number of different elements of information. So first, the level of community spread. Second was the health system's capacity in terms of looking at hospital utilization, how quickly people could get tested, how the number of tests that were actually being conducted, test positivity rate, rate of transmission, new cases from quarantine contacts. So this dashboard was a way of aggregating information from the Center for Disease Control, from DC's own health data, to provide greater transparency and actually try and answer questions that citizens might have beforehand. There were other elements of information that were in the dashboard as well. So public health system capacity. Of the people that were getting tested, how many were being contacted for contact tracing? And then crucially, community engagement. How many points of contact were there between public health officials and officials in government with citizens who might have been exposed, as well as measures like how much of a percentage of people in the city were wearing masks correctly and how many people had COVID vaccination. And this again is updated weekly and has been for over a year and a half in Washington, D.C. You can also see some of the situational updates. This most recent one was from the 20th. It talks about, this is an example where parents are particularly interested in the city about school-based testing and how that is coming into play. And so it provides information there in terms of school-based testing. It also provides information about where you can get further information in terms of public outreach and public disclosure. So they have information that's there. So those are examples of how you can take principles of access to information and put them into practice in such a way that it meets a critical need of citizens during times of crisis. So I will leave that there and look forward to the further discussion amongst the panelists.
Thank you so much for that. And we will go next to Ms. Blanca Lilia Ibarra Cadena, who is the chair of the National Institute for Transparency, Access to Information, and Personal Data Protection, as well as heads the international network of close to 60 access to information supervisory institutions, the International Conference of Information Commissioners. Ms. Cadena.
¿Qué tal? Muy buenos días, muy buenas noches.
Good afternoon, good evening. Thank you very much. And I regret not having been able to connect before for problems we had, but I'm very happy to greet you now from Mexico. And I would like to greet you on behalf of my commissioner colleagues at INAI, and especially at this very special day. And I'd like to thank the UNESCO for this initiative to celebrate such an important date. And without a doubt, in the presidency of UCIC, which is occupied by INAI, and in the celebration of today, we are invited to think about how we can build better institutions based on an efficient use of information, so that with international cooperation we can assure sustainable and inclusive development. And I make this reflection because it is also relevant to remember that from its acknowledgement during or in the Rio Declaration in 1992, access to information has become a key element for assuring more responsive, fair, and participative societies. And in this context, the availability and the use of information becomes important cornerstones in order that we can achieve the objectives of the 2020 Agenda for Sustainable Development, based on which we will progress on the expansion of human rights. Now, according to the Center for the Development of Democracy worldwide, there are 127 national laws that attempt to assure the right to access to information. by public authorities. And of the countries where these laws have been identified, 78% have a guarantor agency or institution that protects this right. And without a doubt, the presence of these agencies make it easier for society to have access to information through more expedite means, and also to grant this right to any person. These policies and laws are implemented based on the assumption that public administration is obliged to make available to society the information that authorities produce and safeguard. So based on the synergy that is triggered before between the existence of laws and their guarantors, the attempt is not just to increase transparency and account rendering and trust in government, but also the understanding of what government should do and the participation of the peoples in the decision-making process. And we also have to stress the improvement of efficiency and efficacy of governments. Despite these breakthroughs in the understanding about the relevance of access to information, we still have hurdles and resistance that has to be taken into account. For instance, in some regions, governments are not receptive enough in order to share information. Citizenship may also have little awareness about this right, or there are structural barriers that prevent them from exercising this right. So I believe it is important for government institutions to work within their realm of influence in strengthening their resources and also in improving training so that they can have more experience and also updates on this matter. But in order to counter these difficulties and to strengthen laws, we have to provide the resources to assure these rights. And on the other hand, if I may, I insist on the importance of educating public servants, which leads to facilitating the provision of this information for the dissemination and keeping of information without the need for increasing bureaucratic procedures. So in order to break inertia in this regard, a leadership culture has to be fostered towards a bureaucratic culture that respects the right to information. Those who are decision makers should guide civil servants to openness to scrutiny and horizontal hierarchy, as opposed to, as guarantor agencies, we are called to simplify and not to complicate the requirements to access to information. So we have to eliminate fees to services or simplify the requirements for filing requests for revision, and also putting at the center communities that have less access. One important element to be taken into account is the development of awareness of the right to access to information. With dissemination campaigns, it is possible to make available to the population tools in order to exercise their right to know. It is also mandatory to have guarantor, impartial, independent agencies that break away with the asymmetries of information that remain between citizens and public institutions. With their presence, the implementation of laws is strengthened, and we can achieve shorter response times. With the development of these agencies, we would be achieving greater or higher degree of professionalization in order to have elements that are able to provide sound, consistent, and updated information in order to respond to the demand of these agencies so that they can keep their independence and autonomy from public power. Such independence is achieved on the one hand by the appointment of those who are the heads of these agencies that should not necessarily be part of government itself, and the budget cycles there correspond to, so that they have responsibility on this. And another characteristic is that they should have ability to do research in order to oversee public actions and to institute account rendering instances, organizing discussions with other institutions, and so on. These agencies should also be the interlocutors between expectations and demands of citizens regarding governments. In this way, they will achieve making the consultations between the stakeholders in order to achieve more inclusive governance. At a multilateral level, good practices helps the implementation of access laws. This is why the agencies involved may learn from one another and use networks in order to share experiences. This is a great exercise, and I would like to acknowledge UNESCO for allowing us to share such experiences. To conclude, I would just like to stress that the implementation of access laws to information requires local technical knowledge, which can make information accessible to citizens at the same time that institutional elements are developed in order to achieve this goal. There is not a silver bullet. On the other hand, it is mandatory to build and design collectively ways to improve the implementation on laws on this matter. The celebrations of this day of today, without a doubt, are very important in order to understand the challenges and perspectives that are involved in the participation in public matters. Thank you very much.
Wonderful. Thank you for that. We will go next to Gloria de la Fuente, President of the Council for Transparency of Chile. In addition, she is a political science from the Catholic University of Chile and has taught at various universities in the country on matters related to transparency and the quality of democracy.
Muy buenos días. Muchas gracias.
Good afternoon. Thank you very much to the organisers of this event. This is a very important day for those of us who have been working for a long time in our own countries on access to public information. This is a universal day to commemorate and also to reflect on the challenges that we have today, which are even more significant in the face of this pandemic. So it's very important to organize these types of events. So I'd like to thank the organizers and for allowing us to bring together so many people from different regions of the world. I'd like to share our experience in Chile in the context of the Ibero-American region. We launched a process around 2002 with the president of INAI, who has just expressed herself. In Ibero-America, at the time, Mexico was one of the first countries to introduce a law in this field. And this led to a process which gave birth to a number of laws in our region, including the Chilean law on access to public information, which allows us to enforce the right to information. We also saw the emergence of the first standard in 2010 in the field of access to information, and in October last year, we also approved a legislative model that inspires a number of other countries, and it should be implemented next year. Today, I'd like to tell you a bit about the experience of Chileans, specifically. We introduced a law 13 years ago, and 1.5 million submissions for requests for information have been received. And this law on access to public information recognizes 3 areas of work, in addition to the other issues it establishes. First of all, active transparency, So those who are subjected to these obligations, around 1,000 entities in Chile, must publish information permanently. The second is to establish a mechanism for the request of public information so that citizens can effectively exercise their fundamental right to public information through a clear process with clear deadlines and a well-known process. And then it also establishes the guarantor of access to information, which is the Council for Transparency, which I am at the head of. It's an autonomous agency with 4 commissioners. And I'd like to greet all of the participants on behalf of my colleagues. There are 3 items I'd like to highlight here. First of all, mechanisms to promote access to public information in terms of mechanisms. This is something that we do constantly through training of public officials, awareness among the general public, and a number of different campaigns which are essential to launch a dialogue with society. Secondly, we establish mechanisms for prosecution which are very clear through law, which can still be improved upon. And then lastly, there are mechanisms for sanctions, which is very important to us. The law in Chile foresees sanction mechanisms for entities that don't comply with the law. And we believe that this is an important part of the functioning of bodies for access to public information, because it allows us to improve in the field, in the areas of our competencies. Now, the Council for Transparency in Chile does not have competencies over the parliament or the judiciary. But it does in terms of local governments, municipalities, among others. That's important to recall because the state of access to information shows the state of development of our democracy at different levels of government. There are another few issues I'd like to highlight here. We've made significant progress in Chile towards achieving an integral ecosystem in terms of public transparency. As I mentioned previously, there is a standard that's been in place for 13 years now. But transparency also requires looking at what we're doing within an ecosystem. In Chile, we've not only moved forward in terms of access to public information, but we also have a lobby law which requires the publication of information by entities who are considered to be lobbyists. And this requires declarations of interests and assets with a significant level of transparency requirements. And this allows citizens to hold accountable those who are responsible for enforcing governance. And lastly, Chile, like the rest of the world, puts access to information at the heart of the management of the pandemic. In order to have access to information, in many countries, this required, first of all, trust in decision-making bodies, and then trust in what those bodies are implementing to continue to comply with the instructions of the government in order to fight the pandemic. And in many countries, it's also extremely important to generate mechanisms for access to information which allow citizens to provide checks and balances on the government, especially in the context of a pandemic. In Chile, we've done this by improving access to information through the law, but we've also allowed citizens to exercise their right to access to information and to provide social checks and balances on the government. So my time is running out. I'd like to thank you for giving me this opportunity to share Chile's experience and for allowing me to be here today. Thank you very much.
Thank you for that. And for our final intervention, we go to Mr. Jose Maria Costa, Director of Transparency at the Paraguayan Supreme Court. Dr. Jose Pepe is an expert in freedom of information laws. He is in charge of implementing the access to information law for the judiciary power in Paraguay, and also to advise the ministers of the Supreme Court when they were assessing cases related to freedom of information.
Muchas gracias, Mike.
Thank you very much. Can you hear me?
Can you hear me? Okay. Bueno, desde la Corte Suprema de Justicia.
Well, at the Supreme Court of Justice, we'd like to thank you for inviting us to take part in this UNESCO conference and to the organizers. Today, I'll be presenting the context in Paraguay and Paraguay's experience in this field, and I'd like to mention a couple of issues that we may like to look into in terms of access to public information. In 2014, Paraguay became the 100th country to have a law in terms of access to public information. I think nowadays there are around 130 countries at least that have such a law. In 2013, in the heart of South America, there was a very specific political context. There was a lot of civil unrest and there was a lot of campaigning on access to public information held by the state. There were a lot of claims in this area and a lot of appeals against politicians who were reticent to provide this information. In 2013, in October, there was a tsunami of social unrest, and this led to the transparency spring, as we call it in Paraguay. And the Supreme Court of Justice ruled a historic ruling which stated that all bodies must provide information about the remuneration and the expenses of public officials. This may seem inconceivable now, but at the time it was truly something revolutionary. In the next slide. Thank you very much. Part of these protests in Paraguay in the context of the ruling of the Supreme Court, this allowed what was previously secret to become transparent, and that's why we called it the Spring of Transparency. And this led to the law on access to public information, which was passed in Paraguay in 2014. This has been an essential law in terms of democracy, and it's based on international legislation in the field. There have been over 40,000 requests for public information since the law was passed through a portal for access to information, which allows citizens to request information via digital media, computers, phones, etc. However, this law does not establish an explicit guarantor or body to ensure the enforcement of this law. And therefore, the judiciary became the first and last instance or resort in terms of access to information. So the judiciary, the Supreme Court of Justice, ruled a number of other important sentences which have shaped the transparency process in Paraguay. For example, the declaration of assets of public officials must be made public. Citizens must have access to this information. And over 100 cases of at the Supreme Court generated jurisprudence on the issue of transparency. But is this sufficient? Is the Supreme Court and the judiciary sufficient in terms of being the guarantor of this law? We believe that, of course, it would be better to have an administrative guarantor body with sufficient autonomy and independence to ensure compliance with the transparency law. In Latin America, there are a number of countries with the guarantor bodies with a certain level of autonomy, but in other countries, they do not exist. So this would be a significant improvement. I'd also like to take this opportunity to discuss other issues related to this right to information. At the moment, in the times of pandemic, there seems to be a worrying step back in terms of human rights and the right to expression and information in particular. Corporations are imposing their rights above the rights of individuals. States are being subjected to rules of play. And this undermines their capacity to ensure rights. Pharmaceutical companies are imposing barriers to access vaccines. In some cases, it's been difficult to overturn the power of big corporations in order to determine what can be published or not and what is true or not. So this is a serious dystopian situation which jeopardizes these human rights, which we have always said are in progression, but today, unfortunately, seem to be moving backwards. In George Orwell's 1984 book, that reality seemed very far removed, but today we have fintech companies playing Big Brother with our rights to express ourselves or not, which information is censored or not, life and death in social media. If we look at this from the judiciary perspective, we see that Facebook and others have created their own judiciary system, which could be based on their own ideology. For many years in South American countries, there have been dictatorships, censorship of freedom of expression, and those who were opposed to the regime. This reality, which unfortunately is still present in some countries, has unfortunately led to a number of issues with access to information. And this is jeopardizing the most fundamental rights of human beings, such as right to information. And in the face of this situation, we can only express concern. What can we ensure in terms of the rights of citizens? Unfortunately, our rights are being violated in a sustained manner, and this really must call us to reflect and to act collectively in solidarity to support human rights. Thank you very much.
Thank you for that. So we will now go to a brief video presentation from UNESCO before we have a few minutes for Q&A and discussion among the panelists.
the right of access to information as a Palestinian journalist is very important to grow integrity and transparency and, of course, accountability, because we need some consequences to hit people actions in our society.
I urge government entities to respect the provisions of our Constitution and of our law, the Access to Information Law, and the regulations thereof, to be proactive in providing information to the citizens.
Thank you for that. All right, so we're going to move over to a discussion among the panelists now, and we have heard quite a bit about differing legal standards as well as practical implementation strategies across the different jurisdictions that are represented. I want to start by asking each of the panelists what they see as the advantages or value adds of having an independent oversight body, an information commission or a commissioner who is there to provide that oversight and to assess and support implementation in that way. Maybe we'll start with Quinn Mchugh, who can provide more of a international standards approach, and then we can ask the individual information commissioners in turn. And I would ask each of you to please limit your responses to just 1 minute, so that we can get as much back and forth as possible.
Sure. Thank you very much, Michael. I mean, from our perspective, looking at the different regions in the world and different places where there are laws, it was the point I made at the beginning, which is that the implementation is where things are falling down. And that's where it's absolutely critical to have independent commissioners or an oversight body that can ensure that things are actually moving forward, that governments are putting things in place, that it doesn't stop at law, it goes to the implementation, where people actually have the ability to have someone to turn to if those rights are not being realized in practice. So at a very high level, without someone looking over the store, nothing happens.
Thank you. Short and to the point. Maybe we'll go in the order the speakers went. Ms. Commissioner Tidd.
Thank you, Michael. I'm going to pick up on Quinn's point because it was a very well-made one in relation to watching over the shoulder. Data, reports, oversight and providing that information not only to the agencies themselves that are subject to the regulation, but so too to citizens. So there's complete transparency as to which agencies are performing well in timeliness and are not performing well in release rates, for example. So standard measures and regular reports that are publicly available. I think the point about cultural change comes from a champion of open government, and that cultural change can be assisted by not only best practice and outlining how implementation can occur well, but also the ability to table a report publicly in Parliament as to performance that is very much substandard. So it's an encouraging regime, one that depends upon negotiation and influence to affect culture, but also one that has those other abilities to report, recommend, or potentially direct to achieve better compliance standards.
So you'd say that form of public pressure is quite important then, and the commissioner as almost a moral voice or a voice to indirectly pressure government agencies through public statements is important.
Yes, one of the most influential things that we've done collectively as Australian Information Commissioners has been to report on national metrics. So not only do we report on our regulated entities, but we also report on state by state and the Commonwealth of Australia as well. Now that enables people to look at how well jurisdictions are performing And we've coupled that with a jurisdictional compendium setting out the law so that there's an insight into what the law actually requires and what the results of that statutory regime looks like. We're also coupling it with citizen attitudes, community attitude survey regularly, and key or optimal features, very much based on the principles that Quinn outlined.
And to Gloria de la Fuente next. What do you want to comment on what you see as the value add of independent oversight?
Sí, yo quisiera hacer
Yes, I'd like to make a point about autonomy or independency, which was the original question, which I think it is important, not just administrative autonomy for agencies in terms of access to public information, that is, that they do not depend the authority of the public government, but they also have to have autonomy regarding a political cycle. This should be a collegiate agency that should be independent from the political cycle and not correspond to political elections, because, and then there's another very important thing about learning in Latin America, that is budget independency, a way of pressuring public agencies in many countries, and this is the experience in Latin America in particular, is through the budget. So independence from the political science cycle, and also independence from politicians, so administrative autonomy and budget autonomy, it seems to me very important to me.
And I guess I'll pass that question along to Mr. Costa. You work in a judicial context, so I imagine the context of your answer is going to be a little bit different, but would be interested to hear your perspectives on oversight.
Sí, yo mencionaba.
Yes, I was mentioning that in the case of Paraguay, the significant experience, which is unprecedented, if I may say so, is that the judicial power acts as a guarantor organ or agency, because there's not one provided for in the law. The law is now being reviewed so that we can have an independent agency with the due autonomy and enough power over all of the spectrum of the state. But my reflection about what I was already mentioning in my presentation, that yes, we agree that we have to have guarantor agencies that are independent and that they have their own budget, that are separate from public authorities, so that they can impose their decisions and so on public information. But when we ask this question about to what extent can there be power given to these guarantor agencies, we face this problem that we see in the world that I was referring to in my presentation. Namely, if the pharma companies, for instance, said that we cannot disclose the contacts on vaccination, what guarantor agency in what country of the world will be able to impose that this information has to be disclosed and has to be given to the public because it is public interest information? So we are in a situation where we can think it is an utopia to think that the states will have a decision power on imposing their laws or imposing the rights to people in face of global corporations. So I don't know if this is possible, but at least we have to take the struggle forward.
So, a couple of you, I think, mentioned strategies or the need to support better practice by governments. I wonder if each of you has thoughts about strategies for positive engagement with governments, or maybe I shouldn't say positive engagement, maybe I should say effective engagement with government agencies, and how you approach the problem of overcoming resistance and promoting a culture of transparency. Maybe it makes sense to start with Commissioner Tidd and go through the other three of you, and then we'll go back to Quinn Mchugh maybe to comment on that, on the responses that we heard.
Thank you, Michael. I think the engagement has to represent the legislative authority. So what powers does the regulator have? How independent are they? And yes, I agree entirely with independent appointment by Parliament, defined statutory terms, independent budget, etc. And as an administrative oversight with a power of recommendation for reviewing decisions, that's how we operate. But that statute is largely geared towards influencing. The coercive powers are limited. So the influence as a regulator, in my view, is best achieved by ensuring that your regulatory interventions are targeted and able to be implemented by the agency itself. If the recommendations are too difficult, too onerous, not practical enough, the resistance is quite extraordinary. So we've spent a lot of time refining recommendations for systemic change to ensure that they are practical. So we try and know our regulated entity through various forms. We give them a dashboard to report themselves, and they then report to us. We can also see them publicly, and we describe to them how they sit against their peers. We then also look at their systems for managing access to information and try and promote a more efficient, workable situation. And the benefit for that is one that the agencies will generally be motivated to achieve if it is more efficient. We also have the power to report to their minister, their responsible minister, and the responsible secretary by way of reports that I try to cultivate to be very clean, very sharp, very concise, so that there is real visibility at the absolute responsibility. And under the legislation, I also have offence provisions, which I have had cause to consider, even in relation to the Premier of New South Wales's office. So having that suite of tools in a statute and having demonstrated their utility, I think is also highly persuasive.
That's interesting. Ms. De La Fuente, do you want to go next?
Sí, perdón.
I'm sorry, I was in mute. Yes, I'd like to refer to what the representative of Paraguay was saying, and I think that this is part of the challenges, as I was saying in the beginning, in thinking about the future. I think that, of course, about disclosure about vaccines all over the world, access to information is made more difficult because part of the contracts of countries that they sign with pharmaceutical companies prevent access to information. In Chile, we had several requests for access to information from civil society, and we granted this information just protecting what would be vulnerable. For instance, the production chain. If I disclose that, I'm going to damage the process itself. But usually we provide this information, and several international pharmaceutical companies, except for one, did not start a lawsuit against us, which would be the procedure in Chile. So much of this information is of public availability or knowledge. So we've been making progress, but of course we have many challenges in this regard. So strengthening and having several guarantor agencies in the world, access to information has been expanding in countries, but I think that around the world we have challenges, and this will have a bearing in our future, and we will have to make a lot more progress in assuring rights. Thank you.
And Mr. Costa, again, it's a slightly different context, but I imagine still very relevant in terms of the question of how you approach engagement with government agencies.
Sí, yo creo que
Yes, I believe that there are two crucial elements that we have to start developing based on the work of commissioners and guarantor bodies. And I think that they're related to specialization of this work in attempting to assure right to information. And this specialization implies the creation of a transparency culture in governments and states. So many states, and in Latin America, we still have a lot of that. We have the consequences of dictatorships. The culture of transparency is still a novelty to many of the peoples, and this culture has to be nourished. So we have to create a greater amount of coercive power on the part of guarantor countries. Gloria was alluding to the Chilean case, and I didn't know that, and I am very interested in it. May we have many cases like this and not several of those that we have had in several countries where pharma companies threatened to withdraw or cancel their vaccine contracts because of the dissemination of information on vaccines. So I think that it is a path that we should be threading.
Yeah, interesting. It's interesting. It's so interesting that you mentioned the past culture of dictatorships and the way that creates additional challenges in supporting transitions to greater transparency. The flip side to that is I would suggest that emerging democracies or countries that have had recent experiences with dictatorship and repressive government, you get a much stronger understanding among the population as a whole about the value of transparency. And I think a healthier skepticism about the exercise of power by governments and a greater vigilance over these rights in some cases, which can be, hopefully in some cases, to be a counterbalance to that. Ms. Mchugh, you're approaching this from a civil society perspective. How do you view the engagement with governments in support of trying to support structural change on these problems?
Well, I want to start by maybe flipping this and say, what is one indicator that governments don't need to pay attention to information commissioners or other kind of oversight bodies? And that gets to budget. And we've seen in some places where the budgets that independent oversight mechanisms have are so woefully inadequate. It does nothing except send a message that the government isn't necessarily serious about their commitment to access to information and transparency. And so I would say that, I mean, it's a bit cliche, but one of the most coercive things that you can have is money, because money is a signifier of importance when it comes to a lot of different agencies. And so I would really say that in terms of, if governments are serious about indicating that they have commitments to a culture of transparency and accountability, even if they're not there, but they're part of a journey, that fully providing adequate resources for those who are responsible for overseeing these laws is absolutely crucial.
And there's been a number of very interesting questions that have come up in the chat, including some of which we've already addressed. There was one that came up right at just very recently that I think is very interesting in terms of the difference between a body with recommendation powers versus a body with binding powers. I think that certainly Commissioner Tidd's earlier intervention about calibrating her interventions to make it likelier to support compliance certainly speaks to that. But I'd be interested in hearing from all of the panelists about their thoughts on that. Starting with Commissioner Tidd.
Thank you. There are different models operating within each of the jurisdictions in Australia. The model that I oversight and work within is one where my review powers of a decision are recommendation only, and that the tribunal is the ultimate determiner. Now, there are issues there for costs for both the applicant and the respondent, the applicant being the citizen. And so there, on that basis, one would argue that it's better to have an administrative body with that determinative power as well, because the cost of going to a tribunal automatically increases. Likewise, the legal resources available to the agency are far greater than they are to the average citizen. So those factors, I think, really probably support more powers in an administrative model because of accessibility. However, we find that we recommend against the agency's decision in about 50% of cases. And look, that's bounced around over 5 years between 48 and 52% of cases. So, and we do have feedback in relation to acceptance of recommendations because we provide a lot of guidance in those recommendations, and it is pretty high. So we're thinking that we operate around about the 70% of recommendations. If I was to compare that to the tribunal in terms of upholding a decision, again, about 50%. So there's, and in fact, I'm sorry, I think that is 50% as a high watermark, and it ranges between about 35 to 50%. Obviously, all agencies would immediately comply with the orders of the judiciary, and so they should. So there's not this factor of what would be increased and what wouldn't. But the administrative model has another virtue in that it does involve direct engagement and not just decisions on the papers. So there is direct engagement with the agency officers who are making the decision, and there are telephone calls and there are emails to bring along a culture of improvement through an administrative model. So I haven't landed anywhere in terms of a favourable model, but I think I have pointed out some of the issues with either model.
Interesting. All right. Why don't we go to Ms. De La Fuente, then Mr. Costa, then Ms. Mchugh.
Sí, yo al respecto de había una pregunta también ahí que me parece.
There was also another question that sounded interesting to me, whether agencies should only make recommendations or whether they should be binding. The Paraguayan experience is that the justice is the one who decides and passes a ruling that is enforced and not a supervision agency. So even if you have an autonomous agency of supervision, there should be this instance that imposes a ruling. Otherwise, we would be with the hope that governments are going to decide whether they should provide public information or not. And this power of imposing decisions, which is also based on a political and social construction that you have to start building in society, and that is related to that transparency culture that one has to foster, not just amongst citizens, but also amongst authorities. It is very frequent when people achieve a position of power, they start to feel the need to limit the people's rights. This is very common, and this is why the culture has to be created, recreated, and strengthened at all levels, even, I would say, from the school days, from the educational system, in order to assure that human rights are understood as something that is inherent to our political systems and democracies and our lives as people.
And thank you. And Ms. Gloria De La Fuente, did you want to comment?
Yes, I'd love to comment on this because this is happening in Chile as well. We have a remedy called the Illegality Remedy, which means that in the face of a ruling of the Council for Transparency, subjects that are bound by this obligation can appeal to the courts. So recently, we had the case of a request that was submitted for a specific situation which ended up in the court, and the court ended up obliging the citizen to pay for the cost of the trial. And in terms of procedure, we believe this is dissuasive in terms of access to public information. And therefore, an important part of the work we have to do in the next 10 years, in the decades to come, is to ensure that this type of case doesn't happen, because making citizens pay for requesting information denies them from exercising that right. And it's important as well because this is in the context of us claiming illegality in the face of the Council of Transparency, and we win the cases in 70% of cases, but in 30% of cases, this isn't the case. So we have much room for improvement. In Chile, there's also a standard for sanctions. We can sanction authorities that do not comply with the law, as I mentioned in my presentation. But of course, in some cases, sanctions are less or are more limited than the cost of trial. So in these cases, there's much room for improvement. Thank you, Michael.
And Ms. Mchugh, your thoughts on the order-making power versus recommendations?
Oh, it's a tough one. I think it gets back to the issues that we've already talked about, and I think someone has raised in the Q&A, that not all information commissioners are created equal, and that there's still some challenges, I think, to ensuring full independence and accountability even at that level. And to me, it gets back to the issue of trust. I mean, people have to have trust in the independence and accountability of the oversight body itself. And that would be, I think, the first step that you absolutely need before viewing kind of the binding nature of the decisions otherwise. In an ideal world, I think we would love for an independent and accountable oversight body to have the ability to have kind of binding decisions being made in terms of arbitrating on some of these issues. And that's, I think, the goal that we need to be working towards.
Okay, thank you. So we have just a few minutes left. So I'm meant to transition us over to the new draft declaration on access to information, which has been developed and published, I think published in draft form now, by Access Info Europe. I'd like to hand it over to each speaker for a very, very short 1-minute commentary, your thoughts on that declaration, and then we can wrap up. Again, maybe the same order, starting with Commissioner Tidd.
Thank you again, Michael. I'm going to be very brief and focus on two issues. There are many more reasons for the need for this declaration, which in draft form is really very comprehensive. One, the focus on proactive disclosure and the value of the right to access information, why it is so important in today's world, is well articulated and needs to be further articulated. So a declaration of this nature is fully supported. Whilst we've spoken about COVID and a contemporary society, one in which climate change is the most pressing issue for us, so too artificial intelligence and how information may be locked away from citizens further by virtue of the utilisation of technology. And it is so important to preserve these rights that are enshrined, either treaty-based or statute-based, so that a move towards digital government does not diminish the right to access information, and the draft declaration also deals with that issue. So I think I'll leave it at that.
Thank you. I'm not sure if we still have, why don't we go to Mr. Costa next?
Sí, brevemente quiero coincidir.
Yes, I agree with the comments that were shared in terms of artificial intelligence. This declaration is very wide-reaching. I believe it covers a number of aspects. Personally, I believe that we need to put special emphasis on the issue of artificial intelligence because it will be, and it already is, an important phenomenon in this new world that we're living in. And it's a key element that will allow us to access information, manage information, and process information. And another item, or another point, in the declaration that we have before us, there's a call to states because states are the guarantors of the development, curation, enforcement of human rights. But there seems to be a parallel universe showing us that they have more power than states, and that is the power of the corporations, as I was mentioning in my presentation. If we do not look closely at this in the context of the declaration, we would be neglecting one of the main issues that we may be facing in terms of the compliance of human rights in the world today and the future.
And quickly to Gloria de la Fuente.
Thank you very much, Michael. I think, first of all, I'd like to appreciate the declaration and the relevance of having relevant data in terms of enforcing laws to public information. We have a huge quantity of information available nowadays. The context is more complicated, not only due to the COVID-19 pandemic, but there's also the climate change issue, which requires recognizing human rights in a more effective manner. So I think the declaration could move us forward in this sense. We have challenges ahead of us as humankind in terms of access to information. We need to put more emphasis on recognizing fundamental human rights so that all citizens worldwide can exercise them. Thank you very much.
And to Ms. Mchugh.
Thank you very much, Michael, and to everyone. I again want to recognize, as others have said, the comprehensive nature of the declaration, which is very welcome, as well as others have mentioned, the intersection of technology and artificial intelligence is desperately needed in terms of being explored about the intersection between access and privacy. One thing I think that the declaration is a little silent on that could further enhance and I think needs to be considered in the context particularly of climate change is the issue of protection of information activists. We saw, for example, in the Escazú Treaty that protection of environmental human rights defenders and environmental access defenders was enshrined in the Escazú Treaty because people calling for access to information are often targeted for that, particularly by those who do not wish to have accountability placed on them. And that would be one area where we could look to strengthen, I think, some of these declarations in the future, is looking at that intersection between the rights and those who are trying to enforce those rights on the ground.
All right, thank you for that. And that just about takes us to time. So I want to thank our excellent and esteemed panelists for their participation. Thanks very much to UNESCO and the ICIC for their invitation and for organizing this. We've had a few questions in the chat asking for a copy of the declaration. It's just been circulated to us. My understanding is that Access Info hopefully should be publishing that shortly, but certainly soon there will be a public consultation process, I believe, related to that. So you can stay tuned for that. And thanks again to all of you. And I hope you all enjoy the rest of your day and the rest of the day's events. Thank you, everybody, and take care.
Thank you.
Thank you.
Adiós, muchas gracias. Hasta luego. Felicitaciones a todos.
Hasta luego.
Thank you very much to everyone.
Thank you, everybody from UNESCO Paris. Thank you.
Thank you, everyone, and thank you, UNESCO.
Bye-bye. Thank you very much.